So hi, I'm Marissa Loya. I'm an associate at Arnold and Porter in the DC office. I'm also a Marine officer. I've served just under 8 years on active duty, and I'm currently in the Marine Corps Reserves. In this portion of the presentation, I'll cover Military Rule of Evidence 412, which is the Rape Shield Law. I'll explain what it is and when a victim's legal counsel might expect to encounter MRE 412 issues in the context of representing military-connected sexual assault victims. So where will you find this rule? You'll find this rule in the Manual for Courts-Martial, which is pictured here on the slide. Depending on when you might need to research MRE 412, just always ensure you're using the most recent edition. As of the time of this recording, the 2019 edition is the operative one. Dealing with MRE 412 is very common when serving as a VLC to military-connected sexual assault victims. When representing a victim as a VLC, it's critical to be on the lookout for evidence that falls squarely under the prohibitions of 412. So how might you do this as a VLC? As with any case, as a lawyer, know the details of your case. It's critical to be able to anticipate possible 412 issues. For example, if you know through your communication with your client that there is potential 412 evidence that the defense or even the government might want to proffer at some point during your representation, you'll want to anticipate any potential 412 objections that you might want to make on behalf of the victim. So what is MRE 412 intended to do? It's intended to shield victims from often embarrassing and degrading cross-examination that is seen in these types of cases. Of note, 412 issues may need to be raised early in the judicial process. For instance, MRE 412 does apply at Article 32 hearings, which are hearings similar to that of a preliminary hearing in the civilian side. So all the more reason to ensure as a VLC, you have a solid grasp of the facts as early as possible in representation to be able to anticipate 412 issues. So transitioning, so what is MRE 412? Right here on this slide, this is the general rule for MRE 412. There are two general prohibitions. That is evidence offered to prove that a victim engaged in other sexual behavior or evidence offered to prove a victim's predisposition. So to flesh this rule out even further, the Manual for Courts-Martial defines other sexual behavior from the first prohibition to include any sexual behavior by the victim that's not encompassed by the alleged offense. As to the second prohibition on the screen, the Manual for Courts-Martial states that sexual predisposition refers to a victim's mode of dress, speech, or lifestyle that does not directly refer to sexual activities or thoughts, but that may have a sexual connotation to the fact finder. So what are some of the potential impacts that 412 evidence, if admitted, can have on a victim? This type of information is the type of information that is typically implicated by MRE 412 is likely to be highly prejudicial to the victim. It's the type of intimate details about the victim that, if shared with a panel, which is the military's term for a jury, can often distract from relevant facts of the case and turn into a side trial concerning the victim's very personal and often embarrassing details about his or her personal life. So for example, the defense might want to seek to introduce 412 evidence that inevitably raises questions in the panel's minds about the victim's morals, and ultimately for the panel to project that the victim is promiscuous or loose. Because if the victim appears either one of those things to the panel, then it's probably more conceivable in the minds of the panel that the alleged crime was not a sexual assault, but rather was a consensual sexual encounter. This is precisely the type of inquiry that 412 is intended to shield against. So transitioning to the next slide, as is usual and as the case with rules of evidence, MRE 412 has exceptions, which is depicted on the slide. There are 3 exceptions total. The first exception is evidence of sexual behavior by the victim that may be admissible if offered to prove someone else, not the accused, was the source of the semen, injury, or other physical evidence. The second exception is evidence of sexual behavior by the victim with respect to the accused, offered by the accused to prove the victim consented or offered by the prosecution. And lastly, the third and one of the most enumerated exceptions is the constitutional exception, specifically states evidence the exclusion of which would violate the rights of the accused. So this next slide shows us the MRE 412 trial test. So if the military judge determines on the basis of the hearing that the offered evidence is relevant and that the probative value of the evidence outweighs the danger or unfair prejudice to the victim's privacy, the evidence shall be admissible under MRE 412. So teasing this out slightly further, the highest court in the military states that the dangers of unfair prejudice include harassment, prejudice, confusion of the issues, the witness's safety, or interrogation that is repetitive or only marginally relevant. Also note that evidence is still subject to challenges under MRE 403 and other evidentiary challenges. So taking a step back, we've covered what MRE 412 is. So next, I'll just transition us to just a sampling of cases in the military courts to highlight some common 412 issues that a VLC might encounter and to showcase how courts interpret what may or may not constitute MRE 412 evidence. This slide shows a smattering of the military cases in both the military's appellate courts and the military's highest court, which is known as the Court of Appeals for the Armed Services, or CAF. As a side note, when representing military connected victims and attempting to make 412 arguments on the victim's behalf, it's important for the VLC to understand what the various military courts mean to one another in terms of binding and persuasive authority. So as a brief overview, before jumping into the cases, the military courts, the military's highest court, the Court of Appeals for the Armed Services, is binding authority on all lower courts in the military justice system. Cases in sister services serve as persuasive. So for an example, if I'm representing an active duty Marine sexual assault victim, I'll want to look for opinions from the military's highest court, the Court of Appeals for the Armed Services, and then the Navy and Marine Corps Court of Appeals. Then I might want to branch off to sister service opinions, perhaps in the Air Force or the Army or Coast Guard, for additional persuasive authority to support my argument. Of note, if there is not an MRE 412 case on point in the military courts, it is advisable to look to the federal courts for case law on the Federal Rule of Evidence 412 for persuasive authority. So switching gears back to the sampling of cases on the slide, some common 412 issues that a VLC might encounter include the defense offering evidence that implies that the victim is promiscuous, as we see in US v. Greaves, which I will discuss in just a moment, or the accused attempting to offer evidence that the victim accused others of sexual assault in his or her past. So starting with US v. Greaves, this was a case before the military's highest court for review. The accused was a male sergeant in the Air Force convicted of sexual assault. The victim was a female petty officer also in the Air Force. The defense's theory was that the accused reasonably and honestly, albeit mistakenly, thought that the victim was consenting to sexual intercourse. In support of his theory, the accused wanted to introduce evidence about the victim's employment background to demonstrate why his mistaken fact as to her consent was, in his view, reasonable. Evidence that he sought to introduce included testimony that the victim had been working after duty hours as a hostess at a bar known for entertaining married Japanese men. Also, evidence that the victim told him that she had earned quite a bit of money or a good amount of money working at that bar. The accused also sought to describe how the victim dressed up for work at the bar, specifically that she wore lots of makeup, exposed as much of her body as possible by wearing see-through shirts and very lacy type bras. The court in its analysis said that it was clear that the accused wanted the court members to project that the victim was in fact a prostitute or at least extremely loose woman. The court essentially deduced the accused's efforts to an insinuation that the victim was extremely loose or easy, which the court said was the type of inquiry specifically forbidden by MRE 412. The court went on further to say that though the victim may have worked at a Japanese bar, dressed provocatively, and made good money, that the evidence in no way would add to the perception of a reasonable person in the accused position that the victim was specifically consenting to his advances on the night of the assault. So as a VLC, I might look to rely on a case like Greaves to highlight apparent attempts by an accused to insinuate a certain level of promiscuity by the victim, which again is forbidden by 412, unless an exception applies. Switching gears to another common 412 issue that a VLC might encounter, if evidence of a victim's past sexual accusations against others. So for example, the defense might seek to introduce evidence to show that the current accusation against the accused is false. And to demonstrate an alleged false accusation, the defense might seek to impeach the victim's credibility by any and all means practicable. So as a VLC, I might consider looking at United States v. Erickson as a starting point on the issue of prior sexual assault accusations. The Court of Appeals for the Armed Services in Erickson makes clear that prior accusations of sexual assault are presumptively inadmissible and can only be introduced where there is a reliable evidence of false accusation. The court states that to be admissible and not barred under 412, that prior accusation has to be proven to be false. And according to Erickson, it's not enough that the prior sexual assault allegation ended in an acquittal by a summary court-martial, or that there was a denial by the accused, or that it was unfounded by a third-party agency to be considered proven false. So as a VLC, it's easy to imagine how daunting and traumatizing it can be for a victim of sexual assault to have to rehash and relive past trauma with the potential introduction of evidence regarding past sexual assault accusations. So it's important to look for this potential 412 issue as well. And then lastly, transitioning to the last two cases on the slide, these are examples of military courts' interpretations of the first general prohibition under 412, specifically what is and is not considered other sexual behavior protected under 412. So specifically, some courts have found that when the proffered evidence is inextricably intertwined with the alleged offense, is not considered other sexual behavior protected by 412, but rather becomes testimony admissible as part of the same transaction as the assault. Both of these cases were both before the Army Court of Criminal Appeals. So starting with United States v. Shelmity, the court found the proffered evidence here was temporally and physically separate from the charged offense, and therefore considered other sexual behavior protected by 412. In that case, the sexual assault occurred in an upstairs bedroom, followed by what the accused described as a sexual encounter with the victim downstairs on a couch later that night. The defense sought to introduce the evidence of that alleged consensual intercourse on the couch as necessary because it went directly to the accused defense that the victim knew who he was during the assault, and that by seeking the accused out after the assault, the victim must have clearly known his identity. Ultimately, the court determined that the break in time and space between the alleged offense, the assault in the bedroom, and the second allegation of consensual encounter on the couch made it such that the downstairs encounter was considered other sexual behavior and was therefore inadmissible and protected under 412. Conversely, when we look to United States v. Gaddy, the temporal separation between the offered evidence and the assault were closer in time and space. In Gaddy, the accused sought to introduce evidence that he and the victim, an Army private, had engaged in highly sexualized dancing that simulated sex, including grinding in the moments immediately leading up to the alleged assault, to support the defense's theory that the sexual intercourse was consensual. There, the court said that it did not see the provocative dancing immediately before the assault as other sexual behavior under the protection of 412. The court said that when conduct is inextricably intertwined with the alleged offense, it is not considered other sexual behavior, but rather becomes testimony admissible as part of the same transaction of that assault. And that was Gaddy. So taking a step back, there are certainly many more cases in the military courts that cover a wide range of 412 issues that a VLC might encounter. But these four cases can at least serve as a jumping off point to understand the types of 412 issues that are out there. So before I conclude the MRE 412 portion of this presentation, I just want to reiterate some key takeaways. So when representing a military connected sexual assault victim, know that MRE 412 issues are highly likely to appear and may appear early in a VLC's representation, as early as in Article 32. So as the VLC, it's important to know the facts of the case to be able to anticipate those MRE 412 issues and know the general prohibitions under 412 and its 3 exceptions. And know to look for case law in the military courts to bolster any MRE 412 arguments that as a VLC you may have to make on behalf of the client. This concludes the MRE 412 portion of the presentation. Thank you for your time.